In February 2019, the Home Secretary notified Shamima Begum that he intended to deprive her of her British citizenship, on the ground that she was a British-Bangladeshi dual national who had travelled to Syria and aligned with ISIL, and her return to the UK would present a risk to national security. Ms Begum was, at that time, and still is, held at a camp in Syria by the Syrian Democratic Forces. Ms Begum appealed against the deprivation decision to the Special Immigration Appeals Commission, SIAC. She also applied for leave to enter the UK in order to pursue her appeal and to avoid the risk of mistreatment. The Home Secretary refused that application, and Ms Begum appealed to SIAC against that decision as well. Appeals have now reached the Supreme Court in 3 sets of proceedings brought by Ms Begum. The first proceedings concern the deprivation decision. As preliminary issues in Ms Begum's appeal against that decision, SIAC held that the Home Secretary did not depart from his human rights policy when he made the deprivation decision, and that although Ms Begum could not have an effective appeal against that decision in her current circumstances, that did not mean that her appeal must succeed. Ms Begum challenged those decisions by an application for judicial review. On that application, the judges of the Court of Appeal, sitting as a divisional court, found in Ms Begum's favour on the policy issue, holding that SIAC had erred by reviewing the Home Secretary's decision instead of applying the policy themselves. The Secretary of State appeals to the Supreme Court against that decision. The Divisional Court found against Ms Begum on the question whether her inability to pursue an effective appeal while in the camp meant that her appeal should automatically be allowed. Ms Begum cross-appeals on that issue. The second proceedings concern the decision refusing her leave to enter the UK. Ms Begum had a statutory right of appeal against that decision only insofar as she claimed that it was unlawful under the Human Rights Act. Her appeal was refused by SIAC, but that decision was overturned by the Court of Appeal. It held that leave to enter the UK must be granted to Ms Begum because she could not otherwise have a fair and effective hearing of her appeal against the deprivation decision. The Home Secretary appeals to the Supreme Court against that decision. The third proceedings also concern the leave to enter decision. As well as appealing against it, Ms Begum also challenged it by an application for judicial review. Her application was dismissed by the Administrative Court, but granted by the Court of Appeal on the basis that leave to enter the UK must be granted to Ms Begum because she could not otherwise have a fair and effective hearing of her appeal against the deprivation decision. The Secretary of State appeals to the Supreme Court against that decision. The Supreme Court unanimously allows all of the Home Secretary's appeals and dismisses Ms Begum's cross-appeal. The Court has identified 4 errors in the judgment of the Court of Appeal. First, it misunderstood the scope of an appeal against the Home Secretary's decision to refuse a person leave to enter the UK. Such an appeal can only be brought on the ground that the decision was unlawful under the Human Rights Act. As Ms Begum did not advance that argument before the Court of Appeal, her appeal should have been dismissed. Secondly, the Court of Appeal erred in its approach to Ms Begum's application for judicial review of the Home Secretary's refusal of leave to enter the UK. It made its own assessment of the requirements of national security and preferred it to that of the Home Secretary, despite the absence of any relevant evidence before it or any relevant findings of fact by the court below. It did not give the Home Secretary's assessment the respect which it should have received, given that it is the Home Secretary who has been charged by Parliament with responsibility for making such assessments and who is democratically accountable to Parliament for the discharge of that responsibility. Thirdly, the Court of Appeal mistakenly believed that when an individual's right to have a fair hearing of an appeal came into conflict with the requirements of national security, the right to a fair hearing must prevail. But the right to a fair hearing does not trump all other considerations, such as the safety of the public. If a vital public interest makes it impossible for a case to be fairly heard, then the courts cannot ordinarily hear it. The appropriate response to the problem in the present case is for the deprivation appeal to be stayed or postponed until Ms Begum is in a position to play an effective part in it without public safety being compromised. That is not a perfect solution, as it's not known how long it may be before that is possible. But there is no perfect solution to a dilemma of the present kind. Fourthly, the Court of Appeal mistakenly treated the Home Secretary's human rights policy as if it was a rule of law, rather than something intended to guide the exercise of his discretion. In this case, having considered detailed assessments by his officials and by the Security Service, the Home Secretary was not satisfied that depriving Ms Begum of British citizenship would expose her to a real risk of mistreatment. SIAC decided that that conclusion was not an unreasonable one. There was no defect in SIAC's reasoning in that regard. The result of the Supreme Court's unanimous decision is that Ms Begum's appeal against a leave to enter decision is dismissed. Her application for judicial review of the leave to enter decision is dismissed, and her application for judicial review of SIAC's decision in her appeal against the deprivation decision is also dismissed.